The theory of separation of powers plays an important role in the development of administrative process. In this video, we are going to see the theory of separation of powers or Montesquieu doctrine and its application in various states. The theory of separation of powers has an ancient origin. The history of the origin is traceable to Aristotle. In 16th and 17th centuries, the French philosopher Jean Bodin and British politician John Locke respectively had expounded the doctrine of separation of powers. But it was Montesquieu, who was a French jurist, he first time gave a systematic and scientific formulation in his book The Spirit of Laws. Now let us see the meaning of the separation of powers. The English philosopher Thomas Hobbes, in his famous book Leviathan, argued that without government, human's life is solitary, poor, nasty, brutish, and short. It means that to secure peace, civilization, the chaos must be replaced by order. It is necessary that government must have absolute power. The problem with this Hobbes' theory of absolute power had varying degrees of success. The problem with this theory is not the power only. Actually, the problem is the absolute or unchecked nature of power. Many philosophers concluded that when the power remains absolute or unchecked, it may corrupt the nature of the mind, and hence the British historian and politician Lord Acton had argued that power tends to corrupt and absolute power corrupts absolutely. The solution to this absolute nature of power was given in the theory of separation of powers. The concept of separation of powers refers to a system of government in which powers are divided among multiple branches of government, where each branch controls different facets of the government. In most of the democratic countries, it is accepted that there are three organs or branches of the government in a state. These three branches are legislature, executive, and judiciary. As it was stated earlier, the theory of separation of powers was first formulated in scientific and systematic way by Montesquieu in his book The Spirit of Laws. Hence it is known as Montesquieu doctrine. In his book, he made a scientific division of powers of the state as legislative, executive, and judiciary. He mentioned that there must be the three powers vested in three distinct and different authorities if the liberty of the individuals has to be guaranteed. Thus, he pointed out that there was no liberty when the legislature and executive powers were in the same authority. That means legislator should not be the executive. Again, there is no liberty if judiciary is not separated from the legislative and the executive authority. If the judicial and legislative powers are joined, the liberty would be subjected to arbitrary control. That means judges would not be the legislator. And if the judicial and executive functions are joined together, then the judges as executive might behave with violence. It means there would be end of everything if all the powers are vested to the same authority. This theory of separation of power has gained success because it was based on the protection of individual liberty. The aim of the theory is not to create the absolute barriers in between the three powers, but to impose mutual restraint in the exercise of powers by these three organs, which are legislature, executive, and judiciary. We can say that separation of powers means all the three organs of the state or the government should not interfere in the working of each other. We can mention here the observation made by Wade and Phillips. According to them, the doctrine of separation of powers can signifies the following three different things. First is that the same person should not form the part of more than one of the three organs of the government. One organ of the government should not interfere with the other. And third one is that the one organ of government should not exercise the function assigned to the other. Let us see the applications of the theory of separation of powers in different states such as France, USA, England, and India. French administrative law is known as droit administratif. The application of the separation of powers in France leads to the rejection of the power of the courts to review the acts of the legislature or the executive, the existence of separate administrative courts to adjudicate the disputes between the citizens and the administrative authorities leads to the theory of the separation of powers in France. In United States of America, the theory of separation of powers was categorically adopted in the making of the Constitution. In the Constitution of United States of America, the executive power is vested in the President, legislative power in Congress, and the judicial powers in the Supreme Court and the courts subordinates thereto, according to Articles 1, 2, and 3 of the Constitution, respectively. In USA, the President is not the member of the Congress. He appoints his secretaries. His tenure does not depend on the confidence of the Congress. He cannot be removed except by impeachment. However, the United States Constitution makes departure from the theory of strict separation of powers, as there is a provision for judicial review and the supremacy of ordinary courts over the administrative courts or tribunal. There is not a strict application of the separation of powers in the Constitution of United States of America. Now let us see the situation in England. In the British Constitution, the Parliament is the supreme legislative authority. At the same time, it has a full control over the executive. The harmony between legislature and the executive is secured through the cabinet. The cabinet is collectively responsible to the Parliament. The Prime Minister is the head of the party in majority and is the chief executive authority. He forms the cabinet. The legislature and the executive are not quite separate and independent in England. So far as the judiciary is concerned, the independence of the judiciary has been secured by the Act of the Settlement, which provides that the judges hold their office during the good behavior. This settlement was done in 1701. The judges, according to it, judges are liable to be removed on the presentation of the addresses by both the houses of the Parliament. They enjoy complete immunity in the regard to the judicial acts. Thus, there is no exclusive province of any organ, and hence the separation of powers has no direct application in England. In India, the doctrine of separation of power cannot claim any historical background, but still Article 50 of the Indian Constitution provides that the state should take steps to separate judiciary from the executive. Though there is no direct use of the word separation of power in Indian Constitution, we can observe the overlapping of functions in the Indian Constitution. We can take the example of Article 53 and 74(1). According to it, the President is the head of the executive and acts on the advice of the Council of Ministers. President's or Governor's assent is required for all the legislations. The President or the Governor has the power of making ordinances when both the houses of legislature are not in session, as per Article 123 and 212 respectively. This is the legislative power of the President or the Governor. The ordinance passed by the President or the Governor has the same status as that of the law. The Chief Justice and the other judges of the Supreme Court can be appointed by the President under the Article 124 Clause 2 of the Indian Constitution. The President or the Governor has the power to grant pardon under the Article 72 and 161 respectively. Under the Articles 105 Clause 3 and 194 Clause 3, the legislature, besides exercising law-making powers, can exercise judicial powers also in case of the breach of its privilege. Under Article 61 of the Indian Constitution, the Parliament has power of impeachment of the President for violation of the Constitution. Also, the judiciary can strike down the laws which are ultra-vires to the Constitution. Also, they can declare the unconstitutional executive action as void. These are few examples of overlapping of powers between executive, legislature and judiciary as far as the Constitution of India is concerned. Now let us see what is the judicial opinion about the separation of powers in India. For that purpose, let us discuss some of the important case laws regarding the separation of powers. The first case law among them is Ray Delhi Law Act. In this case, the essence of the separation of the powers is discussed. It was held that the separation of powers, though not the part and parcels of the Constitution, in exceptional circumstances, it is evident in the provisions of the Constitution itself. In Ramzabaya v. State of Punjab, the Honorable Supreme Court held that the Indian Constitution has not indeed recognized the doctrine of separation of powers in its absolute rigidity, but the functions of the different parts or branches of the government have been sufficiently differentiated, and consequently it can be very well said that our Constitution does not contemplate assumption by one organ or the part of the state of functions that essentially belong to other. That means there is no rigid application of the separation of powers in the Indian Constitution. In the landmark case Keshwanand Bhati v. State of Kerala, it was held that the separation of powers is a part of the basic structure of the Constitution, and none of the three organs of the government can take over the functions assigned to the other organ. In Indira Gandhi v. Raj Naren, it was observed that in the Indian Constitution there is separation of powers in a broad sense only. A rigid separation of powers, as under the American Constitution or under the Australian Constitution, does not apply in India. At last, we may conclude that the theory of separation of powers or Montesquieu doctrine is based on the assumption that the three functions of the government, that is legislative, executive and judicial, are independent or distinguishable from one another. While deriving the doctrine, Montesquieu has given the importance to the individual liberty or freedom. Theoretically, doctrine of separation of powers was very sound, but many defects surfaced when it was sought to be applied in real life situations. Practically, it is not easy to draw the demarcating line between one power and the another. Hence, it is said that strict separation of powers is a theoretical absurdity and practical impossibility. The modern interpretation of the doctrine of separation of powers means that the distinction must be drawn between the essential and incidental powers, and one organ of the government cannot encroach the essential functions belonging to other, but it may exercise some of the incidental functions thereof.